We're here to talk about defending someone else. When can you do it? When can't you? When can you defend a third party? What's the state of the situation, the state of Washington, and what's a criminal defense attorney's perspective or opinion when you need to defend yourself, or when you need to defend a third party? And it happens to be it happens to be statutorily driven by the same statute that allows you to defend yourself, which is
9A-16020. And in general, the law allows you to mistakenly defend an initial aggressor, the person who initiated the fight, provided you weren't there when the fight got started, because that compromises everything. All of a sudden, you can be viewed as being an individual who is just helping out the initial aggressor to pummel somebody else, and that does not work to your favor.
Well, I mean, stepping back one on that, right? Mm-hmm. When we're talking about the law allows you to defend somebody else.
Right.
Right. And the law allows you and gives you all of the same protections that somebody, as long as the force is reasonable, mm-hmm. and as long as it doesn't exceed what somebody else, I suppose, is facing. So it gets really interesting if you see your friend with a gun pointed at them, and perhaps and you don't know what happened before that. I think that's why you jumped right into the mistaken issue.
Right.
You are allowed to, and you meet the force with force. In that case, perhaps deadly weapon, deadly force with deadly force, and that's some of the issues. So that's really a hot topic, I guess, from our perspective in dealing with defense of third parties or defense of others is, well, what if you don't know what happened, but you walk in on a fight and you're sticking up for your friend, you're sticking up for somebody else? And it's good to know in the state of Washington, there is some give in that topic.
Right. Mm-hmm. And in general, the law allows someone to be mistaken in their belief that another is in danger. However, sometimes a protector will come to the defense of another because they perceive that their friend or that person is actually in danger, when in fact they are not. Even if it's later proven that the individual you thought was in danger was the aggressor and was the one getting the best of the other individual, you are protected because you're coming to their aid, not knowing all of the facts of the case, so to speak. So there is a chance that you could be coming to the aid of the initial aggressor. You may not go to jail. The initial aggressor may very well go to jail, but this is one of those statutes that protects you and not the initial aggressor.
Yeah, and it may allow, a prosecutor may, or prosecuting agency, may initially make a decision to charge you with it, but as the facts are fleshed out and we complete our interview process and the details of what went on, that's when really the idea of you were defending somebody in good faith, and starts surfacing and becomes obvious to the prosecuting agency what was going on. And it hits one of my favorite legal terms from law school, mens rea.
Yeah.
Right? And that really means your internal intent, what you intended to do internally. Were you defending somebody else in good faith, or were you jumping in to administer an additional beating because you knew what was going on and you wanted to beat the other guy up as well?
Right.
And that becomes an interesting issue with defending third parties.
But in all of these situations where we're talking about an affirmative defense, and that's what this is once again, in an affirmative defense, you can only use reasonable force. If you've got a guy that's just, cold cocking somebody, you can go back and grab the arm and try and get him off, but you can't hit him with a 2x4. So you basically have to use the same type of forces as being used against the individual that you're trying to protect. If you escalate it, that's when you don't allow yourself to be using this affirmative defense, and you can end up being charged as well.
Well, let's talk about an affirmative defense too. What does that really mean? It means that you have to affirmatively prove that defense to a jury, or let a prosecutor know you are going to affirmatively, there are facts sufficient that you can prove by preponderance of the evidence, more than 50%, that in fact you needed to use that force, so it was reasonable under the circumstances. And then the burden shifts to the prosecutor, who has to prove their case beyond a reasonable doubt, to also prove beyond a reasonable doubt that your use of force was not appropriate.
Right.
And then also immediacy, right?
Right.
And these kinds of, and on any self-defense case.
Right. Anytime you're using an affirmative defense, you have to be in a situation where you had no other choice. It can't be a situation where you think about it and then come back a day later and cold cock the guy.
It's got to be an immediate threat.
Yeah, it's got to happen right then and there, or else you lose the ability to use it.
I had somebody try to really wanting to have an affirmative defense of defending themselves, but the problem was that the bar fight was 3 hours before, and they had already left. Yeah. And unfortunately, maybe if the guy pursued him, then the circumstances would have been different. But that emotional feelings, the law does not have emotion, and it can't. It's just trying to make general rules to say when it's okay to basically assault somebody else or to come to the defense of somebody else.
Right.
Anytime you're into these kinds of facts, I think you got to talk to a lawyer that's familiar with the criminal defense system, who has tried these kinds of cases, is familiar with these kinds of cases, familiar with how prosecutors look at it, and can articulate things in the way that juries understand.
Right.
You know, on a gross misdemeanor, a lower felony, that's 6 people that'll be looking at your case. On a felony,
It's 12.
yeah. And so,
If you find yourself in this type of a situation, call us. We can help you out. Make an appointment. Come on in.
certainly talk to you about it.
Yeah.
Thank you.